that step. Okay, so now we're going to turn to the argument itself, and I was in the process of making sure I had the clock right and the podium right. I think we do, right? We're all good to go. Any other questions from the attorneys before we begin? I'm going to call the first case.
We need that microphone returned up here to the...
We have that.
Oh, you've got your own.
Oh, okay.
How fancy.
Yeah, we're used to seeing a microphone on the podium at our home venue, but anyway, I guess that's been handled. Okay, the first case we have on the calendar today for oral argument is a case captioned State versus Christensen. It's case number 20230033. I'm going to ask the attorneys to enter their appearances for the record before we begin.
Rachel Phillips Ainscough for the appellant Isaac Christensen.
Good morning.
Jonathan Bauer for Appellee State of Utah.
Good morning. Welcome, and thank you for being here. Ms. Ainscough.
It's a little bit smaller. Make it all fit. Okay. The district court abused its discretion in denying Isaac's motion to sever the charges. Under the Utah Code, Section 77-8A1, charges must meet two requirements to be joined for trial. First, they must be sufficiently connected, and neither party can be prejudiced. There are two ways that charges can meet the sufficiently connected prong under the statute. The first is that they can be based on the same conduct or otherwise connected in their commission, or two, they can be part of a common scheme or plan. So as to the first prong here, the charges were not based on the same conduct or otherwise connected. And this part also has kind of two subcategories, the first being precipitation. And this is not a precipitation case. Aggression alone is not enough to show precipitation. As recognized in the briefing, a classic precipitation case is one of crime facilitating flight from an earlier crime, and that's the Benson case that's cited to in the briefing there, where the defendant committed multiple robberies, stole a car, and used that in the subsequent robberies. Is it just this microphone work? It's little.
It's cutting out a little bit.
Okay, but as long as you two can hear, or you three can hear me, we're good. Okay.
We can hear, and let's just pause for a second.
Yes.
Are you listening to make sure this is being? Yes, it's working. Okay.
Yeah,
we are recording this as well. We want to make sure we're not only being able to hear for today's purposes, but we want to make sure we're recording it in case there's a need to go back and listen to the proceedings later. So, yeah, go ahead. Thank you.
Okay, yeah. So here, Isaac's behavior with Katie, Tim, and the officers did not facilitate flight from the sexual abuse charges. There was no evidence that Isaac was aware that Nadine had disclosed to anyone about the alleged abuse, and that the cops were called because of the alleged abuse.
What about
yes.
the comment that your client allegedly made about stop staring at me like a pedophile?
Mm-hmm.
Doesn't that indicate some sort of connection between the events?
Mm-hmm. So Katie and Tim, in their testimonies, they testified that Isaac stated at some point that to stop staring at him like a pedophile. That's not shown in the transcript of the 911 call, but accepting that their testimony there, that doesn't show that whatever, we know from that evening that Isaac was highly intoxicated, and whatever reason that he may have had for making that comment, that again, the evidence doesn't show that that Isaac had been told, neither through Katie or Nadine's testimony, that Isaac had been told about that by another person, or that he was aware that Katie knew about the alleged abuse.
But does he have to be told, or does he have to know in that moment? I mean, in order for them to be connected, right? So maybe he's making that assumption that that's why they're here. He's proceeding on that basis. Why wouldn't that be enough?
And I think here with the evidence, as we can see, whether it's through, we have some body cam footage, we have the recording of the 911 call, that we know that Isaac was whether intoxicated, or there's other testimony about him being confused and things like that, as to whether what he may have known or could, was understanding in that moment. So with that evidence of potentially his mental state being impaired at that time. And again, as the defense of involuntary intoxication was, presented at trial as well too.
But wasn't that consistent throughout the evening? Because as I recall, the earlier there had been a FaceTime call, I believe, with the former girlfriend because he was acting strangely, and she was concerned about the phone call, and so had a FaceTime with him afterward, and then received the call from the daughter that she too was concerned because he was acting strangely. So doesn't that behavior feed consistently throughout the course of events?
His intoxication and confusion, yes.
Right.
And I guess just to clarify too, that the call that Katie had earlier, and that preceded, she had that, was kind of concerned, and that I don't think we know exactly how much time had passed before Nadine had called and asked Katie for advice. There was some discrepancy. Katie said that Nadine asked her to come down. Nadine said that she did not ask Katie to come down. Katie came down on her own. But the short version to your question is yes, that Isaac did seem confused and intoxicated throughout the evening.
What's your understanding of what it means for the one crime to precipitate the other?
And I think if I pull up the here for exactly like precipitation, right? That it facilitating, I think, is another good word, like in the Benson case, right? Where we had the first armed robbery and he stole the getaway car, and then that facilitated the subsequent crimes, the subsequent burglar or robberies in that case.
As a dictionary definition, I looked up precipitate, and it seems like there needs to be a causal connection, and if his at least the state's argument would be that he had a consciousness of the abuse that had happened, and his awareness of the abuse, that there could be a causal connection to that's why he would be aggressive when the other couple later arrived. Why is there not a causal connection there, at least arguably?
Oh, sorry, didn't mean to cut you off. But I think to kind of push back on that a little bit, that there was evidence from both Nadine and Katie that Isaac didn't know that anybody was coming to his house. Katie and Tim, they arrived at the house. It was a little after midnight, or around, kind of that very late, early morning time, and that he wasn't aware. And so he hears someone coming into his house. Nadine testified that, or either through her CJC interview that was played at trial, but she stated that Isaac was like, somebody's breaking into the house, right? He didn't know.
I think that there's some, and I'm sorry to interrupt you, but that there's some validity to that, except that there was not just a single encounter with Isaac and is it Kim that we're calling?
Sorry,
who arrived?
Yes.
That there was the initial encounter in the home, but then after she and Nadine left the home, then he went out again with a firearm.
Yeah, because he was concerned. Again, didn't know why Katie had showed up. Katie's testimony, Isaac had asked, like, why are you crying Kim, sorry, we did not use the pseudonyms in our briefing, but I will use them.
I just
the
had that one in my mind,
sorry.
I'm sorry.
That the ex-girlfriend testified that, Nadine was crying, and Isaac said, why are you crying? And she was scared, right? She had a gun and went out, because again, Isaac, as these people came to his home in the middle of the night, they took his daughter outside. Nadine testified as well on page 1448 that Isaac was afraid that they were trying to take her from his home and didn't know why, right? They showed up in the middle of the night. And so again, as a further explanation that it was Isaac was confused and didn't understand what was happening, and people showed up at his house. And as we addressed for the later parts of when the officers showed up, right, all of the evidence there that he didn't know that they were coming or who they were at that point.
But couldn't that mean that they're connected in a way that he knew the conduct that had happened with his daughter before they arrived? These people arrived in the middle of the night. He didn't know they were coming, and he's essentially defending himself and stopping them from interfering, right, and being involved. So doesn't that really cut the other way, at least potentially, to say that these are connected?
I don't think so. Again, I would just rely again on the evidence the lack of evidence that he was directly told and knew that. And again, that Katie, the evidence was that the cops were called and that Katie responded and came to the home because Isaac was intoxicated, and that she called the police, and there was no evidence given to the police that they were responding to a man with a firearm, right? That this was not a sexual abuse allegation, that everybody was there because of Isaac's confusing or intoxicated behavior.
So even if there's not a precipitating sort of causal link between one set of crimes and the other way the state can get there
Yes.
here is if the crimes are so related in time, location, and purpose that they were directly connected in a legally significant way.
Mhm.
These crimes all happened in very rapid succession within a matter of just a couple of hours.
Mhm.
And the state takes the position that, look, it's really hard to tell this story in a sort of holistic, logical way without telling all this. This is all part of the same evening's events. And in that way, these things are connected. This happened, then this happened, then this happened, then this happened. What's your response to that?
So my response to that is that time is only one part of that, right? One consideration. And yes, the timing does weigh in favor of joinder or the connection here, but it has to be more than just a temporal proximity. And so we know here that there was, at least from the time that Katie was called, it took her because she came from, or sorry, Kim, the ex-girlfriend, I apologize. The time that she came from Salt Lake, Midvale, somewhere up there, that it was a couple hours. So yes, the temporal part of that. But again, when we look at the case law and whether it's through the directly connected in a legally significant way about there was no common element or theme between the sexual abuse charges and the assault and gun charges there, right? So just having things happening in close proximity, I think that's kind of like the Gallegos case, where it was a similar happened within a few hours. So we're not just looking at time, but we're looking at conduct, and that goes a little bit more to the common scheme.
Gallegos, it seems to me there was a little bit more of a gap between the one set of events and the other. The events that happened at the park, and then there's an arrest, and then he's taken into custody and driven down to the station and booked into custody essentially, and then they put him in, and at that point, then there's some additional crimes committed at the station house, and that seems a little bit different than this, where all the crimes were committed in the same place in relatively rapid succession. Does that make sense to you, or what's your response to that?
Yeah, I think again that it's not wrong to look at the timing aspect, but I guess my response is timing isn't the only aspect, and we're looking at again going to, I think it's in the Lim case about parallel, and I know that's a little bit under the common scheme or plan, but just kind of what more makes things connected other than just they happen within a close proximity in time, that there is another kind of connection that has to happen, and that here with such distinct acts that the conduct was different in those things. So the timing is not enough in this case.
One of the things that troubles me a little bit is thinking about if you were to have a trial on the gun charges alone, and you'd need to have testimony about why did Kim and boyfriend arrive, and that you'd kind of artificially be cutting off the story. That she'd say, well, I got a phone call from Nadine. What did she call about? Oh, there were troubles at the home. Or, and when you arrived, what was the conversation? Well, we kind of talked about there had been things going on. That you're artificially cutting off really what happened. And the real story that is, maybe precipitating is a good word. It seems like it becomes a little artificial, especially on the gun charges.
And to that point, I would say that just because, and this maybe goes a little bit more into the kind of when we look at the prejudice and the Rule 404B and all of those things. So even accepting that they needed to tell some part of the story, that doesn't mean that everything had to be told, right? They could have said that police responded to this call, that Nadine made allegations, and that they didn't have to hear all of Nadine's testimony, right? All of the things that had happened there, that they still would have been able to tell the story, have that little bit in there without the prejudicial effects, as we've argued in there, right, of hearing it all together and hearing all of those details. So the state would have still been able to the extent, right, that it was admissible, and that they could have limited what was in there.
So let me follow up. Would the witness be limited to saying Nadine made allegations, and then just leave the jury wondering, well, what were the allegations? Why was everybody so upset?
And I guess just, speaking hypothetically or looking at that, or even if they were said that she made allegations of sexual abuse, right? And then just leaving it at that, right? But I think the point is of going into all, the jury did not need all of the testimony, all of the details that the state could have presented to the extent they needed to, right? What had happened there could have done so in a more limited way. That would
And
not.
I want to follow up on the prejudice because
Yes.
it's also your burden to show that there's a reasonable likelihood of a more favorable outcome if the trial had been severed into two trials. And so under those circumstances, we need to look at the gun charges separately. It seems to me that the evidence there, regardless of whether it's presented alone, is pretty overwhelming evidence, right? So with respect to the gun charge case, how was there a more reasonable likelihood of a more favorable outcome?
Yeah. And I guess I would push back a little bit about the overwhelming evidence on those, because again, we have, as detailed in the brief, as I know that you have all read, all of the indications, right, that Isaac didn't know, specific to the police officers, right, that it's the middle of the night, they park down the street, no lights on, they come running down, flashlights in there, everything happened so quickly that there was at least good evidence to support that. That Isaac was not aware, that he did not knowingly and intentionally threaten them with the weapon, as was supported by after the officers testified and said that, once they had returned, Isaac was very cooperative and respectful and supported that he didn't know that.
In other words, you're saying there's evidence to suggest that he didn't know who they were.
And that didn't have the requisite intent.
I mean, he's not contesting, or you're not contesting that he did in fact point the gun at them.
I don't know if we would, Isaac had a gun, yes, we would admit to that, and whether he, I just hesitate to say that, yes, he pointed at them in a threatening manner, but we would not dispute that Isaac had a gun that evening. He had the shotgun, and that the officer saw him with it, but that there would be some dispute again as to intent and whether or not he pointed at them and, with the intent to.
In other words, if
harm
he thinks this is an intruder, for instance, then your point would be that would not be criminal activity. But if he knows that they're police officers and points the gun at them, then we're talking about a different kettle of fish, right?
I think so. And again, importantly here, that the jury was instructed on self-defense and then also defensive habitation. So supporting that. So going to Judge Oliver's question about that there was room in the evidence to support that on those assault charges.
Can I ask about the standard of review?
Yes.
On the motion to sever, the question of precipitation and whether these crimes are directly connected in a legally significant way, I think both sides agree that this is something we review deferentially for abuse of discretion,
Yes.
right?
Yes.
So we'd have to conclude that the district court abused its discretion in determining that these crimes were, sort of connected.
Yeah, and so I think I would agree that it's the abuse of discretion and that there's, this is from the Lim case in paragraph 16, where it says a clear abuse of discretion in that it sacrifices the defendant's right to a fundamentally fair trial, as well as the other standards that we talk about for abuse of discretion about unreasonableness and things like that.
All right. I have, I guess, some more questions about prejudice. If you want to follow up on yours, I don't know if I'm.
And this clock, I know that you are still asking me questions, but the clock
We've got
is going
zeros.
upward at this point, so I don't know what that means.
Ours has zeros, and we still have questions. So,
Yeah.
so we're gonna, if you wouldn't mind bearing with us for another minute or so.
I wouldn't say I gladly do so, but I will do so.
Refreshing candor, thank you. My question has to do with Judge Oliver asked you about prejudice or harmless error prejudice on the gun charges.
Yeah.
We've also got to look at the flip side of that. If we're gonna get that far in the analysis, we've got to look at whether there's whether there's a reasonable likelihood of a different result on the abuse charges. And I guess I'd like to hear your argument on that, especially your response to the fact that there was in fact DNA evidence with regard to at least one of the charges. Yeah,
so the evidence here was mostly based off of the evidence of sexual abuse, those charges was based off of Nadine's testimony or in CJC interview. And as far as the DNA evidence, I would point out, I think this is in pages 40 to 43 of our opening brief where we kind of detail a lot of these things, but I'll just highlight a few points in response to that. So there was no male DNA in Nadine's oral swab, which was important because she had testified that Isaac, quote, made her suck him so that he put his penis in her mouth. So that was an important contradiction to that there was insufficient male DNA. And that's on page 893 of the record, also cited in our brief, that there was insufficient male DNA in the pubis to anus swab, which was important because she had alleged that Isaac, quote, licked down there. So again, disputing, or at least creating reasonable doubt there. And now this is a point that was referenced in in the briefing about the penile swab showing human alpha amylase, and that was not saying that there was saliva in there, that there was testimony that this could include other bodily fluids, like tears, saliva, and fecal matter, and there was important evidence that.
Am I misunderstanding the evidence, though, that the minor profile on that evidence pointed almost conclusively to Nadine?
Yes, there was from that, and that there was the testimony with non-sexual reasons for why two people who lived in the same home, why their DNA could show up in there, whether that was like touching the laundry or the fact that, again, they lived in the same home, that there was expert testimony for that and how DNA can, I don't know if spreading is the right word, but especially for people living in the same home, how that wouldn't be uncommon or point to just a sexual reason for why the DNA would show up. Her DNA would show up. And I will point out too, as part of that, with the swab, there was also the concerns about what's the word that I'm looking for? The appropriateness, right? It was an untrained person who collected the swab, used the wrong material, and things like that. But,
so if we pull out of that trial, the hypothetical trial in which the abuse charges go to trial separately, if we pull out of that trial any evidence that your client pointed the gun at these officers and really anybody else, give me your best argument as to why why the evidence you just discussed gets looked at in a different way. In other words, in the trial we had, the jury was persuaded by all that evidence you just described. So we've got to think about whether in this hypothetical trial we pull out the gun stuff. Why do you think the jury would look at it differently?
Yeah, and I think as we outlined in the briefing, and I will point out the other points of the concerns that we had about Nadine's testimony and the improper influences. So not just the inconclusive or lack of physical evidence, but some of the other concerns there. And that these were serious charges, both sets of it, whether it's sexual abuse of their own child, and then threatening officers in relation to that. And so hearing everything together, so saying like, oh, this is so awful, having Isaac doing all these things, and then the cops came, and all of that just created a improper basis for the jury to base its decision when there was, as we've outlined in here and discussed today, about the room for reasonable doubt based off of Nadine's statements and the inconclusive DNA evidence.
So is the argument essentially then that it was cumulative, for lack of a better word? It was that we have bad things happen with respect to the gun charges, bad things happen with respect to the sex assault charges, and because it involved the same person doing allegedly two sets of bad things, when you add them together, you've got double the bad things, and so it makes a jury more likely. I mean, is that the essence of the argument?
I think so, and just creating, an improper basis for them to overlook some of those concerns in the evidence, having looked at it all together.
Because it's not a specific piece of evidence from the gun case that affects the sex assault case or vice versa. It's more the atmosphere of the nature of the charges being combined before the same jury.
I think that's correct.
Why would it, if the trial had been severed, and why at the abuse trial, it seems to me that the gun evidence may still have come in to show consciousness of guilt. Why would the gun evidence not have come in the abuse trial as evidence of consciousness of guilt?
I would just rely on my previous statements for the same reason again about how Isaac didn't know, right, that there was no evidence that he knew that anybody had been told about that, and also his intoxicated and confused state with that.
Seems like that cuts both ways. That if there is evidence that he did engage in the abuse, and if he did, he would know of that, and being intoxicated on top of that may have caused him to be defensive, whether he was specifically aware that it had been disclosed or not.
And I think that was not as relevant as I thought it was, so I don't know if you still have another question, or if I was just going to ramble on about something that you didn't actually have a question on.
That's all I had to say.
If there's no other questions, we would ask the court to reverse.
Okay, thank you. We appreciate you bearing with us with the extra questions. You'll have your full time on rebuttal.
Thank
Mr. Bauer, your turn.
Thank you, Your Honors. May it please the court, counsel. The state's brief explains how the trial court acted well within its discretion in holding a single trial in this matter and in admitting the evidence that was admitted at the single trial in this matter. But the court really must affirm Mr. Christensen's convictions for a more basic reason, and that is his failure to meet his appellant's burden of showing that either one of his alleged errors here caused him prejudice. In other words, it was harmful error, as the court has been discussing. On the sex and child abuse charges against Nadine, we have her uncontradicted trial testimony. We have that confirmed by male DNA on her pubic region and her DNA evidence of her saliva on the defendant's penis, consistent with her uncontradicted testimony of forced fellatio in the home. And additionally, his self-identification as a pedophile and statements afterwards. And of course, on the gunshot, pardon me, no, there were no gunshots. On the shotgun crimes, same story, uncontradicted witness testimony, captured on a 911 call, captured on officer video of the officers scattering when they're perceived they're being threatened. There is no reasonable likelihood of an acquittal on either of these charges, any of these charges, with or without separate trials on any other evidentiary picture.
What do you make of the argument that if we had a separate trial on just the gun charges, that trial without the abuse evidence, the jury might be more inclined to believe Mr. Christensen's position that, hey, I didn't realize these were officers. I thought these were intruders, and I was pointing my gun at them in self-defense. Why would that not be something they could argue?
I think that, well, there is evidence. It's not conclusive evidence, but it's an inference. Again, when you look at the whole picture, which is what the state is asking the court to say is appropriate here, that if the allegations as a whole are true, Mr. Christensen knows that he physically and sexually abused his daughter. He knows that, according to Nadine's testimony, when she called for help, she told him that help was coming in the form of the prior girlfriend, Kim, I believe, is what I'm referring to her as. And then Kim shows up, and she's in his house, and they calm him down. And then Nadine is crying again. Nadine says, "I'd like to speak with the girlfriend privately." Christensen allows that. If he knows he just molested this girl, and then she wants to talk to a trusted adult who arrived to rescue her, what does he think they're going to talk about? It's certainly an inference. Then they take her outside. She's on the phone. He's suspicious that she's on the phone. He asked her, are you playing games with me or whatnot? She claims it's the grandmother, but it's an inference that he knows it's not, particularly when 4 men with flashlights, presumably pretty bright cop flashlights, come charging up the way shortly thereafter. It is a reasonable inference he knew exactly who was coming, and he made a statement that was testified to. If that's the Carbon County Sheriffs, I'll put a slug in their head too. And there is no,
in other words, the jury believed that evidence as it was, right? In the combined trial.
Yes.
The question is, would they have believed that evidence to the same degree in a separate trial with the abuse evidence pulled out? And that's what I'd like your input on.
Well, I think it's the defendant's burden to prove that they wouldn't have, and I just don't think that's here. If the court listens to that 911 tape, it captures events leading up to the officers arriving, and particularly the last 2 or 3 minutes, is extremely probative, and particularly as to the civilian assaults, the shotgun assaults. But then you see the officers scattering too, and you hear all 4 officers testified. At least 2 or 3 of them, I believe, direct testimony. He was pointing a weapon at me. They could see the weapon. They could see the scope. This is uncontradicted evidence. There was simply no evidence to the contrary.
Remind me, were they uniformed officers?
I'm sorry?
Were the officers uniformed at the time?
I do not recall if, I think perhaps there was a mix.
But they did arrive silently, essentially, right? They did not
They
come with
did arrive
sirens and
silently.
lights.
If you listen to the whole 911 call, that's because Kim was begging them to do that so that he would not react with the shotgun. She obviously knew him. They had lived together. She knew he had multiple firearms, and presumably she knew him well. That wasn't entirely explored on the record.
Let me ask you about the connection between the cases, right? So the appellant is telling us that this isn't a precipitation crime because there's a gap in time, right? There's the travel time between Salt Lake County and the arrival at the home, which is roughly 2 hours. And they're really independent acts, if you will, right? So one's a gun crime and one's a sexual abuse, which aren't in the search situation inherently related, right? One isn't necessary to accomplish the other in way maybe stealing a getaway car is to accomplish a robbery, right? So setting aside the time proximity, and whether that 2 hours is enough or not enough, what other things can we look to see the sort of fluid connection between the activity here and the allegations here that support the district court's decision?
And I think I'll answer your Honor's question sort of generally without trying to particularly peg it into, we have, these multiple, I'll call them tests, but they're not really tests. They're ways courts have looked at paths to get to the statutory requirement of otherwise connected. It's not like if you go off the path, you necessarily fall off the cliff. It's just, it might be another way to get to the common plan or scheme otherwise connected, or the visual connection, I think, is one of the case law talks about. And so sure, you have the same location, essentially, Christensen home and property. You do have the extremely short time frame, short on its own merits, of, in the case, hours, but also short in the sense that it's only 2 hours because it's as soon as help could get there. If she had called a trusted adult across the street, help would have been there in 5 minutes. If she had called, across town, 20 minutes. She called for help across state. That's where her trusted person was, and that's how long it took to get there. And obviously, the jury could make inferences about how serious that call was, that it convinced someone to get in the car and drive 2 hours. She wanted that person there, and that person agreed to come there.
But at the time of that call, no abuse had occurred yet, right?
It is not entirely, that seems to be the sense of the testimony, something the district court relied on, that perhaps another connection here is, there's a theme throughout the evening of escalating in some senses, if not every sense, of dominance, of control, of Mr. Christensen being drunk and weird and scary enough to this young girl that she calls for help. Then he is told, hey, I've called someone's coming to stop you from being scary. And he, perhaps in retaliation or dominance, sexually assaults her, forces her to give him fellatio, is what she testified to. And then help arrives, and then Kim comes into the house, he threatens her with a shotgun. I don't think that's a charged act because they kind of settle that down, and he becomes aware of who she is. And then, as I alluded to earlier, she speaks with Nadine. They go outside. Then he goes outside and he's trying to, no, my daughter comes back inside with me. It's time to go to bed and it's time for you to leave. Well, and I'm going to shoot you and turn your head into a water balloon or something. I can't remember the exact testimony. And then, of course, when the officers arrive, he escalates that again to, again, not legal escalation, but if you listen on the 911 tape, it is escalating behavior by any common language definition of that.
As we walk through this analysis, could we at a minimum eliminate common scheme or plan? And here's my specific question on that where is there evidence that as the unfortunate parts of this evening began, that he was scheming or planning to abuse and threaten and had thought this scheming and planning seems to mean forethought to me. Is there any evidence that he had forethought that I'm going to do all of these things tonight?
I think my answer to that, Your Honor, is his actions don't meet the phrase common scheme or plan to my mind either. I think what Your Honor just described. But if you look at the case law defining that as similar fact pattern, proximity in time, visual connection, you've certainly got proximity in time. And then the similar fact pattern it's a line drawing exercise, and the district court and
really
myself would draw it as to saying, look, this is a drunken dominance, verbally, physically, armed on civilians, armed on police officers. It's a visual connection, and it's really connected either way. If he doesn't know, I think Judge Oliver, you made a comment. There are aspects of the defense argument that if he wants to say, I didn't know who these strangers in my house were, and that's the defense you're going to, then it becomes relevant that nothing happened earlier in the house. Obviously, he didn't testify. But there simply was no contradictory testimony from anyone either in the home before the adults arrived or from any of the adults who arrived, civilian or law enforcement, that anything happened other than as was described in court without contradiction and all but confirmed by physical DNA evidence, 911 call, and body cam video. I would like to reiterate particularly with sex crimes, particularly with both sets of crimes, just the lack of prejudice from holding the trial together here, where you have the uncontradicted testimony, you have the DNA evidence, you have the 911 call, you have the video evidence. No jury was going to acquit, acquit merely because they might not have heard in full detail the full set of what happened. It was just the full set of crimes here and the full set of crimes here. The point is, they've got one story in front of them in sworn testimony, that they've got no other story, and they've got confirming evidence.
So if the sexual assault charges are tried separately, is there a scenario where the events with the gun charges would be admissible?
Absolutely, Your Honor. And I guess the question would be as with any evidence, is it relevant? Yes, it's not. It doesn't go to particular elements of the later crimes, but it explains to the jury why would this person literally put the lives of people he knows and law enforcement officers and himself in danger with this shotgun. Why does that happen? Well, one explanation is because you just did something really bad and you know that you're about to be held to consequences for that, whether it's legal consequences or losing your daughter or these things. You want to cover that up by driving these rescuers away, God forbid harming them. Thankfully, that did not happen. But so it's relevant. It makes it more likely than not that that these were criminal acts later than self-defensive acts. And then the question would be, well, is it excluded as character evidence or under 403? And I think the answer is no. It would be a discretionary ruling. But this is not a character purpose that it would be offered to show. The idea isn't, well, he's a bad person. He abused his daughter, therefore he'll threaten police officers. That's not the inference that's being offered for. The inference that's being offered for would be motive to conceal, to drive off the rescuers. And so that would be admissible for a non-character purpose on that ground as far as it goes. And I believe the only argument on 403 that would keep out was that it would lead to a verdict based on emotion rather than the evidence. And I think that argument is not without force, except that on both sets of charges, you would never get to emotion because if you just look at the testimony on the confirming DNA or the confirming video, it's not an emotional verdict when it is additionally based on overwhelming evidence and uncontradicted evidence. So I don't see where it would be excluded either way, Your Honor. If the court has no further questions, I would, the state would ask this court to affirm Mr. Christensen's convictions.
Okay, thank you, Mr. Bauer. We appreciate the argument.
Thank you.
All right, rebuttal, 3 minutes.
I'd just like to make, looks like 4 points on rebuttal. To the first point, just talking about, again about the DNA evidence, Nadine's saliva was not found. It was human alpha amylase, sorry. And as we talked about before, and as we detailed in our briefing about how that can be tears, fecal matter, and that there was evidence that that could have been something else. So that
It could have come from saliva.
It could have, yes, but to say that that's what it was, that was not what this test
It could have
showed.
come from saliva, and it was indisputably hers.
No, that just shows that it's the DNA and the HAA. I'm pretty sure that they can't determine the source of the HAA. It's which was the point that Isaac's nurse expert witness talked about how it could have been the fecal matter from his underwear. So I don't think.
I think maybe Judge Harris was making the point that there was indisputably there was her DNA.
Yes, but that's separate from the
Whether her
from the
DNA
HAA.
came from saliva or from household interaction.
Yeah, so there was two kind of separate parts of from the serology test, being like the HAA, I think is what the state is referring to when it talks about the saliva, but that the test did not show that it was saliva. The test showed that it was HAA, which to Judge Harris's point, could have been saliva, but it could have been, as Isaac's expert witness testified, could have been fecal matter, could have been tear, like there was other sources that it could have been. So that was not conclusively her saliva.
It could have been, again, let me just sort of restate this because I think this is right, but I want you to tell me if it's not. is that it could have been saliva from saliva, but not necessarily was from saliva. And it definitely identified her.
I think that there was DNA, but again, I don't think that the HAA, which was the saliva, fecal matter, tears part, I think they're two separate tests.
Where did
that
the
we're
DNA come from if not from the amylase?
I think that was found from the swab. Or I'm not sure of that, but I guess I just wanted to make the point.
Yeah, that's why I'm confused, because I thought all this came from the same swab. I thought this all came from, I'm just reading from the briefs, we're talking about the sample from Christensen's swab contained 2 DNA profiles, and the minor profile on that was consistent with Nadine's, estimated to occur once in 43 trillion people, right? So that's conclusive of her. My question is, which DNA is that referring to? And do I have a misunderstanding about the record there?
I'd be happy to, without having and pulling it back up, so I'd be happy to submit a 24J letter on this, but my understanding is that there are 2 different aspects of it, which is why Isaac's expert witness was important, that it could have been that the HAA hit to that rather than the DNA could have come from the fecal matter, from the smeared stains in his, but I'm happy to, again, without looking at my notes.
And I guess the follow-up question, but if that's right, then why does it matter? If her DNA is on the swab from something other than the amylase, does it matter whether her DNA is on that swab from something other than the amylase? I mean, her DNA is on the swab. Like, isn't that the point? Yeah. So why does that matter?
Just making the clarification, and also because there was the separate explanation for why the DNA, like non-sexual reasons for why the DNA would be present. So that's.
Was Mr. Christensen's expert able to give any probability testimony as far as probability of DNA being on that part of his body just through other?
I don't think that, because she was a nurse, I don't think that she spoke to, again, the DNA probability, but just talked to the HAA and what bodily sources
possible in the broad sense
could have been there. But again, I'm happy to, and if I have misspoken and misdirected the court, I will submit a 24J letter on that. And I wanted to point out again, just a point that was brought up about that on 1442, that Nadine testified that she was pretty sure that Isaac didn't know that Katie was coming to the house. And that the last point being that cooperating with the police isn't consistent with someone trying to escape and to flee from what had happened. Again, the evidence here was that once Isaac knew that it was the police, that he was respectful, cooperative, and I don't know if surrendered, but right, he did not fight, and that it would be inconsistent with someone who is trying to escape liability for those things. And unless the court has any other specific questions. we would ask the court to reverse.
Okay, thank you.
Thanks.
Appreciate your argument. We appreciate the argument from both sides. This has been a very well briefed and well presented case. And once again, we appreciate you for taking the time and effort to travel here today. As with most of our cases, in fact, almost all of our cases, we almost never issue a ruling right after the argument from the bench. We need to go back and talk about it and make sure we have agreement on things. And so there's a contemplative process that has to occur almost always after argument. And so we are going to take this case, as we almost always do, take the case under advisement, and we'll talk together and then issue a written decision containing our decision as soon as we're able to get that decision out to you all. So with that, the first case is concluded. The next case is on at 11, correct? What time is it? 10:55. So let's take a little bit of a break and we'll be back on at 11 a.m. For our next case. Thank you.